This is Andrew coming to you from Realty Now Property Management here in Cleveland. I get this question very frequently, so I decided to make a little bit of a video just answering some of the high-level questions. This was in response to one of our specific clients, so I may give a couple details towards one municipality over the others, but this should be a generalized video. So what happens when your tenant doesn't pay rent, if that ever happens? So we obviously go through what we call the eviction process. So from the day that they don't pay rent, at some point they then get a late fee. After they have a late fee, they then get a 3-day notice. That 3-day notice is the Ohio legal kickoff. You have to give them this warning. This is all Ohio law, that you have to give them this official 3-day notice. There's a format for it. It has to have the right content. Everything has to be done correctly on this 3-day notice. Specifically in some municipalities, Cleveland's very challenging with this, and others, that they may actually throw out your eviction case if the 3-day notice doesn't meet the minimum legal requirements. So we need to make sure that we get that correct. We deliver that 3-day notice. It has to be physically posted on the door in a conspicuous manner. It has very specific language in it. We've had this all vetted via our law firm to make sure that we're doing it correctly. That 3-day notice says that they have 3 business days to vacate the premises. Now, that does not mean that they actually have to vacate the premises. They can pay to stay if they'd like to. And obviously, it's our desire that they'd like to, that we would like them to stay, I should say. So once we deliver that 3-day notice, a lot of people just pay right away. We get a number of phone calls. Hey, what's going on? Why did I get this 3-day notice? I'm going to pay you next week. And we explain to them that we give these 3-day notices to everybody who's delinquent. We're going to, try to, communicate with them, do whatever we got to do to get their money in. But in the end, they do have to pay that money, and they do have to pay it timely. On or about the 15th of the month, we then send those over to our evictions attorneys. Now, if we have a lot of people and, it's 2 days to the Friday, we might kick it back a day or two, or push it back if we believe that we're going to be able to drive in some more dollars. Again, once we send it to our attorney, we incur legal fees. They start and they charge us to prepare the complaint and then file it. It sits with the attorneys. Sometimes there's a little bit of a backlog, but it sits with them for some period of time. They then prepare the full complaint. They get everything together. They've got a whole packet of information that they have to submit with the eviction filing. Now, I'm going to take a moment to just explain what actually goes into that eviction filing. In that eviction filing, there are actually 2 concurrent cases. They're aptly called first cause and second cause. I don't have an attorney with me. I am not an attorney, and I am not giving legal advice. I just want to make sure that that's 100% clear here. The first cause is for possession of the property. We are filing a suit asking the court to remove the tenant from the property and return possession of that property back to us, the management company, you, the owner. There is a second cause of action for monetary damage that's filed concurrently. Most courts, there is not an additional fee for filing it. There can be additional fees related to the legal there. The reason that we do that, and maybe I'll make another video about this, is because that's what we want to be able to go to collections against the person. If you have a judgment from the court, you can actually garnish their wages. If they're W-2 employees, you can go to their employer with that and try to get the money back. Again, we do that through a collections agency. They keep a percentage of the money that goes out, or that is recovered, I should say, from collections. But coming back to first cause of action, the attorney then comes back to us, confirms that everything is still on, and then files that with the local court. Depending on the court, some courts have instant, you file it and you get a court date on the spot. Others, you file it electronically and you have to sit and wait, and they will tell you when your next court date is going to be. It's frustrating, but it's out of our hands in many cases, so we are waiting for that court. I'm not going to speak to any specific municipalities, but the different courts do have different timelines. They move through them quicker or slower. They are handled differently, and we could talk a little bit about the different courts and some of the character of the different courts. Generally speaking, we have more challenges in the city of Cleveland. I will address that because it's so big. The city of Cleveland proper has a lot more kind of hoops to jump through. versus the suburbs. The suburbs are a little bit easier to deal with. So during that period of time, once we have filed the eviction, we cannot accept any money from the tenant. If you accept even a single dollar from the tenant, you have to cancel your eviction. So from the time that we give that 3-day notice till the time that we show up in court, we cannot accept money. The tenant owes $1,000 and they say, I got $500 today. I'll pay the $500, in a week. If we take the first $500, we have to cancel the eviction and start over from scratch. So that is why, we don't get on the payment plans or anything like that. You can, once you get to court, ask the court to oversee a payment plan in which those payments would not be a hindrance to a court case. So we wait until the day of court. The day of court, we go in. A number of things could happen. Depending on the court, the tenants may request a continuance. They might not show. They might show up with an attorney. The court may try to get them some legal representation via legal aid society, something like that. Anything could happen that day. So we do show up with all of those expectations. A lot of courts are on Zoom. Many of them are now back in person, I should say. And so that is helpful when it's in person. We can actually see people, figure things out. On Zoom, it's a little bit more difficult. So once we actually go to court, overcome any of those obstacles, continuances, assistance from legal aid, whatever it might be, we then present our case to the judge. We explain and go through a number of questions. Yes, we posted a 3-day notice. I posted a 3-day notice. Where did I post it? I posted it on the door. How much rent do they owe? They owe this much rent. Did they have monthly payments? Did they have a lease? Do they still live there? Do you want possession of the unit back? Once we get through all that, and that's the lawyer asking me the questions, and I am acting as the witness in that case. Usually it's me that would be in court. If everything checks out, they then give the tenant, if they're there, an opportunity to ask me questions. Sometimes the judges will ask, do you have anything that you want to tell the court? And generally speaking, they either don't say anything or they start complaining about they didn't fix the sink, which is fine. That's not actually a defense for not paying your rent. And usually, if everything checks out, the magistrate or judge will rule in our favor and grant us an eviction. When they grant the eviction, there's then usually, again, a waiting period. Let's say a week or 10 days, and they'll say writ. It's a writ of restitution. I don't know the legal specifics of what that legally is, but that's kind of the document that we get from the court that says that we can actually get that property back. And that's when we schedule with the bailiff from the court to go out. There may be a fee, depending on the court, $15, $25 to purchase that writ from the court that actually gets the bailiff to schedule and go out. From that date, the tenant can vacate voluntarily. Some courts will allow us to collect money at that point. If the tenant wants to make a payment plan with us, we still can collect money at any point. And we make this clear to the tenants the whole way along. And I should have said this at the beginning. From the day that we give the 3-day notice, to the day that we file the eviction, till the day of court, till after the day of court, until the bailiff actually shows up, at each one of those steps, we can still accept money and leave the tenant in the unit. So that is, kind of the hope is that we would get that money. There's, at least today in June of 2022, there's a lot of assistance money happening that people are applying for and are able to get assistance money that's helping them and getting them caught up so that they're out of the rears. And then finally we get to the day of move out, and this is again municipality specific. The easiest cities to deal with will have us just change the locks right there, and the tenant is locked out of the unit, and they get, depending on the court, maybe what they call a reasonable amount of time. Who knows what reasonable really is, but we can usually work with the tenant because we've now changed the locks and they want their stuff back. So we arrange a day, open the doors for them, and give them one day to come and pick up their stuff. Other courts may have requirements where we will actually hire licensed bonded movers, and they will move all of the things out of the unit with the bailiff standing there and empty the whole thing out. The other kind of in between is they may have you hire licensed bonded movers and take their belongings to a storage facility where you usually have to prepay like 30 days of storage. So you have to pay for the licensed bonded movers to come out and move the stuff to storage. The licensed bonded movers have their own fee. It's usually hourly plus the cost of a truck, and then the storage facility, whatever it is. Short answer is that it's not cheap to do an eviction when you have to have licensed bonded movers. It's not cheap to do an eviction anyway, but specifically when you have licensed bonded movers, it's not cheap. So once that happens, we move all of their things out, we lock the doors, change the locks, and then we have possession back of the unit, and we can begin to clean, paint, do whatever we have to do to get the unit ready to be leased out again. So that is kind of the long and short of it. We do go back, add all those charges to their ledger for the cost of the eviction, for the cost of the cleaning, for the cost of the lost rent, and we then send that over to the attorneys. I guess I'm going to go into second cause right now, why not? We then send over their ledger to the attorneys, detailing all the costs and what we believe we're entitled to, and we then take that to back to the court, filing with the court. Depending, there's a number of different things that could happen. We ask for the court to just give it to us. If the court has questions or if the tenant disputes our monetary claims, then we may have to go back to court to get that judgment. That takes several months. Collections is a very, very slow process. The collection rate is relatively low. If they have W-2 income, it's a little bit higher, but overall it is relatively low. Excuse me. And we would then go ahead and pursue that in collections, turn that over to a collections agency once we have the judgment, and attempt to collect on it. The collection is on a contingency basis. We don't pay for collections while it's happening, and especially with the rate of collectability on the collections, we, it's good that it's on contingency. Otherwise, we might not consider pursuing that debt. So hopefully that is a high-level review from the tenant going delinquent, delivering the 3-day notice, filing the eviction, waiting for the court date, waiting for an actual eviction date, and then post-move out what some of those things can happen. The timeline on each of those, it just depends mostly on the court, a little bit on the lawyer, what date we actually send it over. Some of it's luck, whether the tenant shows, whether the tenant doesn't show, whether the tenant leaves. We're kind of working multiple angles at the same time, trying to get the money. If we're not going to get the money, can we get them to just vacate and hand us keys back? The goal is to expedite the process of either getting the money or getting them out of the unit with as little expense as possible, without actually having a formal eviction. And we explain to them, your wages will get garnished. You'll have an eviction on your record. It'll be hard for you to get, a rental place in the future. If you're trying to buy, they'll see this on your credit history. So we explain it to them. Some people just don't care, but that's just kind of how the cookie crumbles sometimes. So we do our best, and that is a little bit of the Greater Cleveland eviction overview. Again, I will put the disclaimer here. I am not an attorney. I'm not dispensing legal advice. I am simply advising on my personal understanding of the eviction process, what it is, how it works. So if you do have any more specific questions, we can get a lawyer to answer those, or you can reach out. Thank you.